Chief Justice David Gilbertson, a native of Sisseton, was elected to a 4-year term as Chief Justice of the South Dakota Supreme Court by members of the court in September 2001. He was appointed to the Supreme Court in April 1995 to represent the 5th Supreme Court District and was retained by the voters in the 1998 general election. Chief Justice Gilbertson received his undergraduate degree from South Dakota State University in 1972 and his Juris Doctorate from the University of South Dakota School of Law in 1975. He engaged in private practice for 11 years until his appointment to the Circuit Court bench in 1986. During this time, he also served as Roberts County Deputy State's Attorney and as City Attorney for the City of Sisseton. He is a past president of the South Dakota Judges Association and is a member of the Glacial Lakes Bar Association, the Brown County Bar Association, and the South Dakota Bar Association. Born October 29, 1949, Chief Justice Gilbert and his wife Deborah have 4 children. Will the Sergeant at Arms please announce the arrival of the Chief Justice?
Lieutenant Governor and members of legislature, the Honorable Chief Justice David Gilbertson of the South Dakota Supreme Court.
Thank you. Thank you. Thank you. Please be seated. Please be seated. Thank you for that warm welcome. I really appreciate it. Governor Rounds, Lieutenant Governor Dugard, members of the legislature, constitutional officers, Justice Zinner, all citizens of the state of South Dakota. As I begin my 2nd year as your Chief Justice, it's my pleasure to bring you, for the first time in many years, both an oral and a written report of the state of the judiciary. I am pleased to report to you that the unified judicial system is strong and working well to meet the challenges facing us. In 1889, our Constitutional Convention created 3 separate, co-equal branches of government: the legislative, the executive, and the judicial. This concept is based on the federal Constitution and exists in every other state in the country. While the theoretical concept of the separation of powers is well known, its actual operation can be less clear. For me, it's comparable to the tasks I came to comprehend in my 20 years of service on the Sisseton Volunteer Fire Department. Say you've got a house on fire, and a fire truck pulls up with 3 firemen in it. One gets out, hooks up the hoses to the truck and the hydrant and to the nozzle. A second one runs the truck, the pumpers, and everything on it. The third one goes to the fire with the nozzle and puts water on the fire. Should the fireman, who is in charge of the hoses and the hydrant, get bored, decide he's going to see what else is going on, leaves his post, the hoses start to leak, the hydrant might not work, and no water gets on the fire. Should the fireman who's running the truck get bored with looking at dials and decide to go see what the fire's like, leaves his truck, pretty soon the pumpers aren't working anymore, no water gets to the fire. Should the fireman who's got the nozzle, who is actually spraying the water on the fire, decide he's had enough of the smoke and the heat and the mess, and he's going to go back and sit in the truck for a while, just puts the hose on the ground and leaves, again, no water gets to the fire. The bottom line for firemen, as well as those of us who serve the public and state government, is that we all have our separate jobs to do, and to successfully complete our constitutional tasks, we must faithfully tend to our duties and let those with other duties do the same. From time to time, the judiciary is criticized for decisions it makes, orders it issues, or does not issue. Often, a court's actions are the result of a limited nature of the powers the judiciary possesses. A former justice of the United States Supreme Court stated that being a judge is not a roving license to do good. The federal and the South Dakota constitutions, along with the laws passed by the Congress and this legislature, provide a framework that guides judicial decision-making. Judges are not free to enforce laws that they like, discards the ones that they don't like. They must enforce all laws evenly. The courts are also limited in their decisions by the evidence they receive in an individual case. Just knowing or feeling that a person is guilty is not enough. Our constitutional protections of our criminal system require that a person accused of a crime be convicted only by sufficient evidence proved beyond a reasonable doubt to the satisfaction of all 12 jurors. If the case is appealed to the South Dakota Supreme Court, it is limited to the record that was created at trial. No new evidence is taken, but rather a review of the decisions made at the trial level. In reviewing these cases, we are guided by the proposition that a person is entitled to a fair trial, not a perfect one, for nothing in this life is perfect. Only if there was error committed at the trial which prejudices the rights of a party to a point where it calls into question the outcome of that trial is the case reversed and sent back to the trial court for retrial without the error. Some areas of the law are constant, some are not. If I were able to meet with our constitutional fathers, such as Madison, Hamilton, and Jefferson, despite the 200-year difference in our legal experiences, they and I could converse intelligently in certain areas of the law, and for the most part understand what each other was saying. However, in other areas of the law, societal pressures and needs have forged a necessity to create new legal responses or significantly modify those that exist. Approximately 10 years ago at a judicial educational conference, each Supreme Court justice and circuit court judge in this state was asked to list, in order of priority, 10 things that would most significantly impact the state judiciary in the next 10 years. With no group discussion, it was anticipated that the answers would be diverse. Instead, every judge in that room listed as his or her number one factor the disintegration of the family. This prediction has been prophetic. Those of us who have been in the judicial system for some time see the results of this change on a daily basis. This evolving situation is becoming more of a challenge all the time, not only to work with the individual who is before the judge, but also with family members. Many of our new programs, which I shall discuss later in detail, are in response to this challenge. We are most grateful for the support that has been provided in this area by the legislative and executive branches of our government. I am pleased to announce that a newly updated Unified Judicial System website exists where expanded information is available regarding our court system. The annual report is on this website, and it should provide all of you and the public with detailed statistical and written information regarding the entire unified judicial system. Presently, the South Dakota Supreme Court hears arguments orally in approximately 90 cases each year. This past August marked a new era for the coverage of these Supreme Court oral arguments. In cooperation with the South Dakota Public Broadcasting and the Bureau of Information and Technology, the Unified Judicial System launched live online streaming over the Internet of the audio portion of our Supreme Court oral arguments. Following some adjustments on the audio equipment in our courtroom, in November we officially commenced this program as a new method of accessing our Supreme Court proceedings. This service allows interested persons who do often not attend appellate arguments to listen to oral arguments of an appeal from their home, office, or from a school. This provides gavel-to-gavel coverage of the arguments, not sound bites, which better educates and informs the citizens of this state about the appellate process and their state government. The broadcast is live, and then it is archived on the Internet for access at any time. A schedule of cases to be heard on any of the terms of court upcoming is also available online. This new service includes the 2 terms during which the court travels annually to a high school or college in October, and this year we'll be in Yankton at Mount Marty, and then also in March when we travel annually to the University of South Dakota School of Law in Vermillion. The The court is also currently reviewing the rules for expanded media coverage of its appellate proceedings, which for the first time allowed both still cameras and television cameras in its courtroom. These were adopted as a pilot project following a public hearing in June 2001. A second public hearing is scheduled for February 2003 to address the permanent adoption of these rules. It is also my pleasure to report that the Supreme Court is current with its cases. In fiscal year 2002, we disposed of 428 cases. We are firmly committed to ensuring the citizens of this state the highest quality of justice with timely decisions. For this, I would publicly like to thank Justices Sabers, Conenkamp, Zinner, Meyer-Henry, retired Justice Amundson, and Acting Justice Gord for their hard work and cooperation. At the circuit court level, overall case filings have remained consistent with past years. However, we have seen significant increases in three major areas. While we welcome the use of this judicial procedure by those in need of its protection, the continual increase in domestic protection orders is cause for concern by showing the large size of this problem and the negative effects it has on all too many of citizens who suffer from this type of abuse. In fiscal 2002, there were 2,893 people who appeared at the circuit courts on petitions alleging domestic abuse, seeking the court's protection from other people. In response to this increase, the court is again working with the Department of Social Services to staff domestic violence coordinators both in Sioux Falls and Rapid City to assist victims of domestic violence through a time of high emotions that can be difficult for many. This past year, we also saw a 25% increase increase in the number of felony filings brought to circuit court and a significant increase in small claims filings. For further details concerning the work of the circuit courts and the entire system, I would refer you to our annual report. For the past several years, the unified judicial system has responded to the ever-increasing demands upon it with basically the same number of employees. This has been accomplished through the dedication and the hard work of our personnel throughout the entire judicial system in the state. We currently have 465 full-time FTEs. In prior years, we have sought additional FTEs only when convinced that they were essential to our mission. The Supreme Court and the presiding judges are well aware of the fiscal challenges that currently face our state. For the upcoming year, we will be requesting a budget increase of approximately only 1% in general funds appropriation and an overall budgetary decrease rather than an increase of 0.3% excluding salary policy and health insurance. We believe this budget will allow us to continue to provide the people of this state with an effective judiciary. I would further call your attention that the judiciary in this state is an instrument that provides revenue to various units of government. This past fiscal year, we collected $27.5 million for these purposes as compared to our general fund budget of $25.3 million. Prior to this year, for 7 years, we had the same justices comprising the South Dakota Supreme Court. However, this year we had two changes on the court. First, Justice Stephen Zinner of Pierre was appointed to replace the Honorable Robert Miller, who retired, and then in October, Justice Judith Meyer-Henry of Sioux Falls was appointed to fill the vacancy created by the retirement of Justice Robert Amundson. And on a personal note, I would wish both Justice Miller and Amundson a long and happy retirement and thank them for their many years of distinguished service to the public and to the Supreme Court of South Dakota. In the circuit courts, Judge Jack Delaney was appointed as a circuit judge in the 7th Circuit. Judge Stuart Teedy was appointed as a circuit judge in the 2nd Circuit. Recently, the South Dakota Supreme Court transferred a judgeship from the 6th Judicial Circuit to the 7th Judicial Circuit after we held a public hearing to determine the optimum need throughout the state for this vacant judgeship. At the end of December, Governor Janklow appointed A. Peter Fuller to this position, and he will take office in the near future. The judicial system is not just judges. It also contains approximately 1,650 licensed attorneys in this state. Unfortunately, a few days ago, we lost one of our best attorneys, and that was Jarvis Brown. He made significant contributions both to the legislative and judicial branches of state government. My father was fond of saying that it's a humbling experience for most of us that if we had never been born, the world wouldn't have missed us. It's only those few, those very few, that make a difference that would have been missed had they not been born. And in my humble opinion, Jarvis Brown was one of those people. The unified judicial system has two councils to assist the Supreme Court in the administrative oversight of the courts of South Dakota. There are the Planning and Administrative Advisory Council and the Presiding Judges Council. The mission of the Planning and Advisory Council is to advise the Supreme Court on major administrative and procedural matters pertaining to the resources, technology, demographics, and planning. This council, which meets quarterly, is considering such issues as how to economically provide judicial services to those citizens in counties with rapidly expanding populations, how to provide those same services to citizens in counties with declining populations, court reporting services, and matters dealing with pro se litigation where the litigants represent themselves. The council will submit written proposals and recommendations to the Supreme Court for its consideration. The Council of the Presiding Judges includes each presiding judge from the 7 judicial circuits. Presiding judges have administrative supervision and authority over the operation of the circuit courts, clerk of courts, and all other court personnel within those circuits. The presiding judges meet quarterly to discuss administrative issues and make recommendations when appropriate to the Supreme Court on administrative matters having statewide implication. In February 2002, the UJS began pilot programs in juvenile case management and civil register of action systems in the 2nd Circuit, which is Sioux Falls, Minnehaha County, and Lincoln County. The juvenile portion of the system tracks delinquency, children in need of supervision, and abuse and neglect cases, and has created the building blocks for developing statewide juvenile probation systems. The civil ROA portion of the system tracks documents filed in civil cases and has created the same building blocks for developing a statewide civil case management system. Since 1997, the Judiciary has adhered to the restorative justice philosophy of community corrections. This philosophy balances the safety of the community with victim and community restoration and offender competency building. During the past year, the Court Service Division advanced this philosophy with the introduction and implementation of new juvenile and adult risk and needs assessments. This new era research-based assessment will assist the Judiciary with community safety issues. Additionally, these assessments more specifically identify and target issues within offender populations, thus yielding a more efficient and effective service implementation. Since July 1999, the UJS has been operating the Juvenile Intensive Probation Program. This program continues to yield obvious benefits by keeping hundreds of youth out of the more costly institutional placements of the Department of Corrections. There are, however, less obvious but perhaps equally more beneficial rewards from these programs. Through this program, we have learned that by identifying specific populations of offenders and applying specialized services to these specific populations, positive outcomes can be greatly enhanced. Using what we've learned, we are now piloting a child in need of supervisions project in 2 counties. By changing the focus of the Chins case from a child-centered issue to a family-centered issue, we hope that outcomes can be positively affected. The project is designed around a short-term, 90-day, high-impact treatment model involving mental health, education, and employment services managed by a team including a court service officer, a dispositional judge, and the service providers. The project was only recently initiated, so results are not yet forthcoming. The UJS received a grant for this study, and a sincere thank you goes out to Senator Daschle, Senator Johnson, and Congressman Thune. The UJS is also in the program design phase for 2 projects affecting adult offender populations. One project targets DUI offenders. Since 1994, DUI filings have averaged 9,000 a year, with approximately 7,000 convictions. This particular population severely impacts the citizens of this state and unfortunately has a very high recidivism rate. The Court Service Division is currently studying research-based programming designed for DUI offenders. It is the UJS's intent to pilot this program, along with specifically applied sanctions and penalties to the DUI population within these specific jurisdictions, to measure its effect in comparison with non-participating jurisdictions in South Dakota. The program's effectiveness will thus be measured by comparing the recidivism rates among the two populations. A second pilot design is being developed in conjunction with the Attorney General's office, and it will be implemented to measure the effectiveness of day reporting combined with specific sanctions in reducing recidivism among the domestic violence perpetrator population. The UJS recognizes its obligation to continue to develop alternative programming to address the special needs and unique problems of these specific populations and others. Society changes, and so do we. And as a service delivery system, we need to continually evaluate and test in order to deliver services as efficiently and as effectively as possible. In most instances, probation continues to provide the citizens of this state with an extremely cost-effective incarceration alternative. The people of South Dakota, through this legislative body, have decided that the death penalty is an appropriate punishment in a limited number of cases involving murder. The death penalty has been upheld as constitutional, both by the United States Supreme Court and the Supreme Court of the state of South Dakota. The press has reported that in some states, the quality of legal representation and the fairness of legal proceedings provided to a first person facing the death penalty has been called into question. While it is not appropriate for me to discuss individual cases in South Dakota, I think it appropriate to let you know the general procedure we follow in these types of cases. In South Dakota, cases that involve the death penalty are taken most seriously by those in the judiciary and the bar. Routinely, 2 or 3 attorneys are provided to the accused. Capable veteran members of the South Dakota bar have stepped forward and accepted court appointments to represent these accused. The trial courts have provided the accused with expert witnesses to prepare a defense. Significant blocks of time are allocated for preparation and trial of the case to avoid a rush to judgment. If a conviction results, the Supreme Court of South Dakota allows 200 pages in briefing on appeal by each party instead of the normal 40 pages. 3 hours are set aside for oral argument instead of the 1 hour that is allocated to non-capital cases. Justices spend many months carefully studying the substantial trial record, and our court gives a detailed opinion on the issues raised by the defendant on appeal. All members of the judiciary in this state are fully aware of what is at stake in these cases, and they will continue to do everything humanly possible to make sure the judicial system works as accurately and as fairly as possible. Last year, as I prepared my first message to you as Chief Justice, it was clear that our nation had been attacked, although we were somewhat uncertain as to those who had attacked us and their goals. In the past year, it has become clear that our enemies do not seek to merely destroy buildings, but have as their ultimate goal the destruction of any system of government and society that does not adhere to their dictatorial ways. In their view, the concept of equal justice under law gives way to any conduct that supports their terrorist goals. It is a tribute to our system of government that once again, as we have done for over 200 years, we are able to honor our citizens' legal rights while facing an enemy on the battlefield. History provides us with the ultimate result. This new group of would-be dictators is in reality no different than the other previous tyrannical isms, communism, Nazism, and fascism, which now grace only history's garbage heap. People, when given a chance, will not willingly follow such fanatics. Rather, as was forecast by a great American about 150 years ago, a government of the people, by the people, and for the people shall not perish from this earth. For those of you who wish to question that point, Lincoln made that observation in 1863. What other forms of government in existence in 1863 continue to exist today other than those that let the people decide? In closing, I am pleased once again to report that as a third branch of government, the judiciary continues to be one of the finest in the nation because of the dedication and the hard work of all employees of the unified judicial system who serve with excellence in response to the needs of our citizens. Thank you again for your kind invitation, and I appreciate the opportunity to appear before you.